So I gave myself a title that was trying to articulate something that has been bubbling under the surface of my work generally and my involvement in the Economics for the Anthropocene project. And that's a niggling suspicion that perhaps I and others have a tendency to romanticize Indigenous knowledge and therefore the place that has in ecological jurisprudence. So fitting myself into this session, which is entitled Solution, I have the opposite problem to the people this morning who, were in the problems section but wanted to propose solutions. I'm sort of addressing a solution and then problematizing it. So if I had to frame it as a solution, the solution is that, in the shift from environmental law to ecological law, the approach should not be just to seek techno fixes, better pollution control or whatever, but more a paradigm shift, a change in consciousness. And this was the way, when Peter pitches the Economics for the Anthropocene, it's about getting rid of the long gone parents of these orphan disciplines, and science is now telling us a different reality about our integration into the ecology and so on, and this should be the basis of a new narrative. So it's this whole paradigm shift that has it has an ethical component, what are our obligations to other beings and each other. It has an ontological component. What is it that what is it that exists in our world? Is it subjects and objects? Who are the subjects? Maybe we can expand that and so on. It has an epistemological component. How do we know these things? And an affective component. How do we fall in love with frogs, right? So that was a reference to this morning, the people who are online and don't know what I'm talking about. So, some of these elements of the paradigm shift. This morning class was talking about sustainability as an important concept, ideas of interdependence and systemic thinking, non-human agency and the sentience of the planet or even the climate and so on. So when you start using these keywords, obviously there's a strong resonance with Indigenous philosophies and the idea, of course, that they would be helpful in achieving this shift in consciousness. So this isn't a formal paper. I don't have a PowerPoint. It's really just some kind of fairly unformed reflections on my concern about the romanticization aspect of this. So some of the ways that environmentalists and the people we work with in this project and more generally have invoked Indigenous ideas. So Klaus this morning talked about sustainability, of course, being both a pre-modern and pre-modern European and Indigenous concept. The sort of groundbreaking environmentalists like John Muir and Toho invoked Indian ideas of oneness with nature and harmony and so on. Thomas Berry, of course, greatly influenced by his involvement teaching Indigenous religions and so on. Cormac Cullinan's book on wild law has sections devoted to drawing connections to Indigenous cosmologies and ways of relating to the natural world. Within this project, the law and governance part of E4A, I've introduced work on, for example, in property law, comparing the way that land as space is imagined, comparing the kind of conventional Western property with, which is kind of a Euclidean geometry of area surrounded by border that fits in with an understanding of property as being something that excludes, that is exclusive and it's about control, whereas drawing on work from the north of Australia, you might imagine space as being about connected nodes. So you have a different kind of way of imagining what the land is actually made up of. In about April, I think, we had a Métis anthropologist, Zoe Todd, give a talk about what it would mean to think with place, and she uses examples from the Manitoba watershed where she was raised, about her relationship with fish and the way that fish, in her understanding of in her understanding of the environment, fish are workers that co-constitute métis, that have their own laws, and that we learn through, like fish work with us to help us train our senses in particular ways. And she has this very neat image of refraction, that in order to engage with fish, to hunt them, for instance, to catch them, we need to train our senses not to see them where our senses think they are, because of course light gets refracted and they're actually somewhere else. So that Zoe's piece on fish and law was very interesting, but she actually became very, she had a piece that went viral, and she became famous for a critique of what's called as the ontological turn, which is connected to a lot of the work we're doing in terms of this paradigm shift. So thinking through a different way that the world is made up as non-human agents and sentient climate and so on. So this piece came out of when she attended Bruno Latour's Gaia's lecture series in Edinburgh, and she came out riled up because she heard so much that was familiar to her, and yet not one single, as an Indigenous woman, and yet not one single Indigenous thinker or activist was cited. So, so this piece was all about critiquing the ontology as another, the turn to ontology as kind of another form of colonization. So appropriating appropriating Indigenous ideas without giving credit to Indigenous peoples. So there's a link there between a kind of absence of Indigenous voices in some of the paradigm shift that's taking place, that is clearly linked to structural conditions in the academy, and these are the result of colonial practices of dispossession and so on, and some ongoing violence that's coming out of that. So the takeaway from that is you can't discuss Indigenous ideas without considering the colonial context in which those ideas are present, are made present or made absent. Okay, so simple first lesson: include Indigenous philosophies and practices, but of course then there's also a risk of treating knowledge as something you can just kind of find and pick up and take and use. Oh, that's an interesting idea. Let me see where I can run with that. So partly there's a political question there about appropriation and control of knowledge, but there's also, I think, an epistemological issue with what we think knowledge is. Is it an objective? Nicole started with this great painting. You know, the world is, including ideas, are sort of over there and we're over here, and we're separate from them, instead of understanding knowledge as sort of part and parcel of our embodied practices. So and this is one of Zoe Todd's points as well, is that you can't, it's not enough just to reference these ideas, but if you're going to be talking about them, you have to understand that they're embedded in social practices like legal orders, and that they're and that you can't speak about them apart from Indigenous people. So let me give you two examples from my work. I've been following a group that call themselves the Mohawk Traditional Council, that are in Ganawage, next to Montreal, and they have been very active in making representations to, for example, the commissions as part of environmental review processes, and COP21. They've been very active in sort of getting out there and passing their message on about the health of the river and the need to respect Mother Earth and so on. It's very easy to start talking in cliches in these situations, but crucially important is that it always, this discourse of respect for the health of the river and Mother Earth comes in the context of the two-row wampum, which in Canada is one of the basic historical compacts that were entered into by the Haudenosaunee Confederacy and the British colonial representatives. And this is part of our constitutional order. I won't go into the way that it's linked to a kind of much older tradition, and it's understood to sort of come out of a relationship with the ecology. But one point that one of the representatives of this council, Stuart Mayo, keeps making is you can't, the model that we have of including Indigenous knowledge is consultation, right? So what do you understand about species? And he says you can't consult with my people just as individuals. This has to come as part of a legal relationship between our two governments. So that's one example. Another example is, so again, within the consultation framework, the way that, for example, so one major vehicle for Indigenous knowledge is land use studies. So companies who have to engage in consultation, and Carla, this is your work, they want to know, well, what are the sites that are going to be affected? What are the, the habitats, the animals' habitats that are going to be affected? What are the culturally significant sites that are going to be affected? And so there's a whole sort of industry around producing these land use studies and using maps and so on to represent, and some really amazing innovative technologies to try and, I spoke earlier about this kind of Cartesian way of seeing land. Well, the map kind of limits us to thinking about land in that two-dimensional bounded space, but there's some really interesting technology using digital time-based technologies and sort of multiple inputs to try and represent a sort of more diverse or sort of richer relationship to land. And yet there's this tendency for the resource proponents and governments to want to take the maps and use them as a sort of substitute for actually dealing with the people. So we know where these sites are now, and we'll plan accordingly, thank you very much. So there's a question of, even if we're situating this knowledge as part of a legal order, is that a positivist understanding of law, or ecological knowledge is simply a fact that can be reproduced on a piece of paper and then anyone can deal with it? Or is it about what we would say in law, jurisdiction, the power, the ability, who has the ability to speak and say what should happen? So without Indigenous interlocutors, these use of stories and law and knowledge can't be held to account. And then underlying all this, I'm coming back to my concern about romanticization. So I wanted to connect this concern to a kind of trope of the ecological Indian, which obviously has resonances to the older European idea of the noble savage. And I won't go into there's a sort of debate in the anthropological literature around, so does the ecological Indian exist, and sort of debunking that by showing, well, in the Pleistocene era, there was this mass mammal extinctions, and then there's other evidence of wasteful hunting practices and so on. There's contemporary decisions of political representatives that end up polluting or, going along with resource development decisions and so on. Yes, there's an idea that this myth, this stereotype of the ecological Indian can actually be dangerous, because it sort of denies the reality, the contemporary reality of Indigenous polities, and anything that goes against, like any opinion that goes against that stereotype ends up being couched as, well, you've lost your culture, or and it's a way of sort of dismissing Indigenous concerns. One of the problems is, though, that Indigenous peoples themselves have adopted this stereotype to some extent, and so it becomes this very fraught question of identity politics, essentially, that in order to make gains in the legal and political institutions, claims have to be legible, and they have to kind of also be desirable. As Elizabeth Povinelli has written about this in the book Cunning of Recognition, that there's this kind of catch-22, that the very culture and the very traits that were sort of sought to be extinguished or assimilated are now the ones that sort of have this coinage in legal claims. So it's very sensitive to be critiquing this stereotype, because it has sort of been adopted with such political capital and symbolic capital in the contemporary era. And I just wanted to finish with some examples from Paul Nadasdy, who says that, in fact, this debate about the ecological Indian and the romanticization of kind of conservative values of Indigenous cultures actually says more about environmentalism and the kind of assumptions that it makes about possible human-earth relationship. And I'll just give a couple of examples from his work with Chloe people in the Dene-speaking people in the north of Canada, where they don't neatly fall along the spectrum from, you know, light green to dark green, where we have a kind of collaboration between the ideas of reverence for nature, holism, everything's connected, and an ecocentricity. And some of the ways that these people would express their idea of respect, for instance, kind of run contrary to what would seem to be to make sense within an environmentalist paradigm. For instance, the catch and release program, where you release smaller fish, one way of understanding that for them would be that it's actually disrespectful to the fish, that the fish has actually given itself to you, and it's disrespectful to throw it back. It's a gift. You don't throw back a gift. If an animal presents itself in the hunt, you're sort of obliged to take that gift. So this is where we end up with, you know, situations where you might have overhunting, which by the way, in a system of reincarnation, the idea that animals can disappear is not because of overhunting, because they can always, you know, go back to where they came from and then come back again. Animals disappear because they're disrespected. So there's, I mean, I've just given a very thin set of examples there, but I guess the trouble that I'm trying to feel out here is what happens when the kind of decolonial politics of respect for Indigenous legal orders and sovereignty butts up against some things we assume about the fundamental principles for a mutually enhancing human-earth relationship. So back to the jurisdiction question, who gets to speak for what ecological law is? Thank you.